Hey, you have Patrick Findaro here, managing partner at Visa Franchise. Excited to have on Michelle Canero, founder of Canero Fadul Immigration. Michelle, thanks for joining today.
Thank you for inviting me.
And we've worked together on multiple cases, whether it's L1 as well as an EB2 NIW case that was recently approved in record time, at least for our clients. So today's conversation is going to focus more on the EB2, particularly the EB2 NIW. But maybe Michelle, we could just open up like, what is the EB2 visa?
So in the employment-based context of green cards, right, what we call immigrant visas, all the employment-based green cards start with EB. So EB stands for employment-based. And there's 5 categories. And they have different preferences, right? So the second category or second preference is what we call EB2. And this is for individuals who have an advanced degree or exceptional ability. An advanced degree can be a master's or foreign equivalent, or it can be a combination of education and experience. So if you have the equivalent of a bachelor's degree and then 5 years of experience after graduating, that can also qualify you as a master's. And then exceptional ability is there's 6 prongs that you need to prove. Most important is showing that you have 10 years of experience in the field of endeavor, and that would qualify you as an EB2. Now, the big thing with EB2 is that there's kind of 2 ways to go about it. The traditional is with a labor certification, which means you're employer sponsored and you go through this process with Department of Labor. But there's a carve out, what we call the national interest waiver exception. And what that means is for certain EB2s that can show that the work that they do is of substantial merit and national importance, they can request a waiver of the labor certification requirement. And this would allow them to self-petition. So that's what you and I have been working on, and that has been a tremendous opportunity for our clients that are entrepreneurs, self-starters, self-employed, or who don't have the ability to get employer-based sponsorship because of either who they work for, how they work, or just opportunity. So I think that
we've seen it with a lot of the STEM professionals, technologists, where they're working in a startup and the startup's like raising funds, they might not make it, they might be acquired, where there's really a lot of uncertainty. So to the extent that someone can kind of take the reins in their own hands and manage their own US immigration process, it's generally going to be beneficial to the new immigrant.
Absolutely. And I think it's also important to point out that all the employment-based categories are numerically limited, right? So we only offer in EB1, EB2, and EB3 about 40,000 green cards a year. And that means every family group takes for each member a number. So a family of 5 is going to use up 5. And that's going to come up in our conversation, but in terms of visa availability, because there's been such an increase in demand for EB2, mostly because of the EB2 national interest waiver and people being able to self-petition, we are seeing those quota numbers being exhausted and the waiting times getting to be longer to get the green card through that process. But just keep in mind, the United States will only grant 40,000 green cards under this category a year.
And it seems, well, looking at the data, that the NIW has really skyrocketed in terms of popularity. What are some reasons you might think that NIW has become such a popular choice for entrepreneurs, STEM professionals, and other professionals in the US?
I really think it's the ability to self-petition. And this is something that historically we always had a problem with. We had companies whose owners couldn't do a self-petition through labor certification. So you could have a massive company with thousands of employees, but your company can't do a labor cert for you because the rules don't allow corporate officers and owners to self-petition, right? So for many, many years, EB2 was under a framework that it was very hard to prove. But we had a case that came out, over 5 years ago, matter of Danisar. And then we started to see the policy changes that really opened up the door to having more individuals qualify under this visa. And as we saw that the feasibility of this strategy, it became more popular. Now more lawyers are sort of treading the waters of EB2 national interest waiver, whereas maybe 4 years ago, they wouldn't have offered it as a potential for their clients.
And Michelle, what are you seeing in terms of recent changes to the EB2 NIW process, as well as it seems like USCIS fees are about to go up.
Well, so it's been like bad, then good, then like concerning. I think when we first started doing significant volumes of EB2 national interest waivers, the processing times were really long, right? We were talking it started to get to a point where we were looking at 2 years adjudication. And then, Congress passed the premium processing rule during COVID, and it took years to implement. But when they finally implemented it, now we can do premium processing and in 45 days get a response. It wasn't all at once. They kind of phased it in. But now pretty much everybody, when they file, can request premium processing, and they'll get a response in 45 days, which is
It
great.
seems like it's sooner than that for the cases that we've seen that chose premium processing.
Right. I mean, for the most part, it is faster, but 45 days is what they're allowed to take, right? So I never tell a client, oh, it's going to happen in less, because I can't guarantee that. They have to respond within 45 days. And the reason that they don't take the full 45 days, if they are going to issue a request for evidence, is because once they issue a request for evidence, they only have whatever time is left in their 45-day window to answer your response, right? So let's say they issue a request for evidence on day 44 and you send them 3 banker boxes full of answer, they're going to have 1 day to respond. So that's why you're seeing there was a response in less than the 45 days, because they know that any RFE is going to get a hefty response. I mean, these are big filings usually. I'd say that our cover letters are anywhere from 25 to 60 pages long. Our packages are a good 24 inches thick. So, and that's just on the initial filing. So I think they're anticipating the volume of work, and they're trying to get through the initial review quicker, but they can take 45 days.
And what should the EB2 NIW petitioner think about, given these changes to the process? Like, when does it make sense, I guess, doing premium processing versus, you would know better than me, like waiting 6 months, say, to get the response on I-140?
Well, everyone has their theories. Even within my own practice, my partners have our theories. Like, some people say, oh my gosh, don't do premium processing. You get the toughest officers. So unless you absolutely need a response, like consular processing cases, I would always say do premium processing, because to wait the regular 2 years, they're stuck outside. If someone has status in the US and maybe it's financially too much of a burden, that $2,500 filing fee, which is about to go up because they have like an inflation increase now, then maybe premium processing isn't necessary. But for most clients, they want an answer. So I usually recommend premium processing. Another change that has come up that I think is important to mention is that in the last 6 months, we saw significant retrogressions, and they're not moving forward. So going back to that 40,000 number quota limitation, what's happening is we've had so much demand for EB2 that they have used up their 40,000 visas available for 2022, 2023, and 2024. So what's happening now is that the people who are able to get their green cards are people that filed for their EB2 in early 2022. And they're the ones that are getting approved. So what's happening is from the date of filing your I-140, you're not going to be eligible for a green card for 2 years. The other part that's important to know is that you may be able to file for your green card, even though they're not going to grant it to you right away, earlier than the 2 years. And that's because USCIS now uses 2 charts. One, it's called final action. So your priority date, or the date you filed your I-140, has to show up on that chart as on or before whatever their cutoff date is. And then they have the filing chart. And so that filing chart is what tells you when you can file your adjustment of status if you're physically in the US with lawful status. So for people that are here, let's say on a student visa, on an O or an H, they're working, and they have their I-140 approved, they're going to have to wait a certain amount of time after filing. It looks like it's about 14 months right now to be able to file their adjustment of status. So this is really important. We've got to maintain lawful status if you're here for a longer period of time than we used to when you could concurrently file. So you can file your I-140, you can maybe get that approved, but you'll still be waiting several months, maybe a year, to be able to file your adjustment of status. And for that, you're going to need to extend your status.
We've had E2 visa clients, for example, that have an approved I-140 or an I-526 for the EB-5 visa, and they're able to successfully get their first E2 visa or renewal. But from what I understand, there's certain visas like the F1 where it can be difficult to get an F1 visa if you have already started that process. Could you maybe talk a little bit about like those non-immigrant visas and dual intent visas, and at
Yes.
what stage do you really have to be concerned and be talking to your immigration attorney?
Well, you're always talking to your immigration attorney. That's number one. Don't ever try to figure this out on your own, because things are always changing and there's nuance, right? What happened to your friend is not your case. And you need to understand that just because someone tells you, no, my case is exactly like yours, there are factors and issues that they may not be aware of. So the main concept here is that we have two types of visas. We have non-immigrant and immigrant visas, right? For the most part, immigrant visas are the ones that say, I want to come and live in the United States. And then you have non-immigrant visas that say, I'm only coming here temporarily for a specific purpose. There are certain non-immigrant visas that immigration has recognized, even though they're all fundamentally non-immigrant intent, meaning you never intend to stay here when you file for a non-immigrant visa, is the concept. But immigration and Department of State have recognized that there are certain people that use these as bridge visas. And so they've recognized that certain types of non-immigrant visas have what we call dual intent, which means you can have an intent to seek a green card and adjust status in the United States and continue to renew that non-immigrant visa, even though you're seeking that adjustment of status. The only two truly non-immigrant intent visas are the H-1B and the L. Everyone else is not dual intent. Okay, so everyone else technically has to prove that they do not intend to adjust in the United States. O's and E's have what we call like a gray area.
Yeah.
And that's because even though the statute says they are not dual intent visas, Department of State Foreign Affairs Policy Manual says that you can have future immigrant intent and you don't need to maintain an unabandoned foreign residence to renew those visas. So what that means is, in practice, so long as your I-140 is marked consular and you have not filed an adjustment of status, then you are eligible to renew your E2 or your O at the consulate. So that's the most important thing. Whenever you have a visa that is not dual intent, do not file the adjustment of status. Do not mark on your I-140 that you plan to adjust status. Always mark it consular. And when you go to the consulate to renew your E or your O, you explain to the officer that you do not intend to adjust, that you are processing your green card consular, and that you will come back to the consulate for them to issue your green card. Because the bar is not on future immigrant intent. You can have future immigrant intent with any visa. As a tourist, you could have an I-130 from a relative that's going to take 10 years. What they don't want is for you to come in on that visa and file an adjustment of status. They want to make sure you're coming back to the consulate. So long as you can always reassure the officer of that, then you can use that non-immigrant visa freely. An example of this, I have clients who are parents, right? They have U.S. citizen children, and the U.S. citizen children are sponsoring an immigrant visa for them. They're doing it consular. They live in Venezuela. The parents live in Venezuela, and they have a tourist visa. That process is going to take 2 to 3 years. But they want to be able to visit their kids on their tourist visa or on their ESTA while that's happening. So what do? I file the I-130, I mark it consular. When they get their I-130 approved, I file a DS-160 with National Visa Center. And then I give my client the proof. Hey, here's my I-130 consular. Here's my DS-160 showing that I'm processing my green card abroad. And then they have no problem coming into the United States on that tourist visa. When CBP stops them because they see the I-130, they explain, no, I'm not coming to stay here. I'm coming to visit. and I'm processing my green card abroad. That's the key. You need to reassure either the consular officer or CBP that your intent is not to remain in the United States
and adjust status.
And adjust status, but to return to your home country if you seek an immigrant visa.
Yeah, I think sadly a lot of people don't get good counsel in the beginning, and they just like show up in the US on a V1, V2, and they
say, oh, I'm going to file my adjustment, and yeah, no. And then you can get hit with fraud on entry, which is a permanent bar.
Wow. What you talked a little bit about the requirements, and we haven't had any clients that didn't have an advanced degree or bachelor's plus 5 years, to the best of my knowledge. What's your experience? Like, are you willing to take on clients that have the exceptional ability instead of the advanced degree or bachelor's plus 5? What's your opinion on that matter?
I think it's happened, right? So we'll have clients who are E2 investors, and they've always been business people, right? So since a young age, they never completed college because they started working, and they have businesses and they have success, but they don't have an advanced degree, right? They didn't complete college. They can't do the BA plus 5. They don't have a master's. I still will do an EB2 for them. I tell them that the probabilities of success are a little bit lower. In our office, our average between STEM and non-STEM professionals is 83 to 86%. It kind of varies, right? We can get a batch of RFEs, and sometimes we get denials. What I will say is that we often will refile denials and get those approved. Those don't fall into my calculation of the 83% approval.
So you're saying the first time approval rate's 83 to 86?
Correct.
And I imagine the final approval rate would be higher. Like similar Visa franchise, our final approval rate for E2 is over 99%. But
right.
That's for people that try a second time or willing to try a second time.
Right. So I don't really calculate. Right. I don't calculate across the board because the refile is very discretionary on the client. Sure. And it's kind of a luck of the draw. I'd say about half the cases we refile get approved, maybe a little higher. So going back to the exceptional ability, I will do it, but I tell the client that the only real way to do it is if you have the 10 years of experience. You've got to at least have that prong, because we're having a lot of trouble getting people approval on exceptional ability that don't have the 10 years. For some reason, the officers hang their hat on that trajectory of experience as a base requirement for exceptional ability. That's not what the statute says. That's not what the policy manual says. But in practice, this is what we see. So long as I can show that they have the 10 years of experience, then I'll look for certifications or licenses or degrees in the area, in the field. I'll look for a leading role in, their organization. If I can show high remuneration and other, the other prongs of recognition. But the big one is the 10 years of experience. Another thing that I think is really important on the EB2 is the element of showing why a labor certification is not feasible. So just generally in the requirements, you've got to show that the person has the advanced degree or exceptional ability. Then you've got to show that the work that they do, not the work generally, but what they will do, is of substantial merit and national importance. And then you have to show that they are well positioned to pursue the endeavor, meaning how are they going to work in the United States? You've got to prove that. So if they're going to do it on their own, they've got to have a business plan. If they're going to be a consultant, they've got to have letters of interest and proposals out there to show. If they're going to work for a company, then the last piece comes into play, which is that the labor certification is not feasible, and that on the balance, right, it merits waiver of the requirement of a labor certification. Now, that's a high burden, because the reason the labor certification exists, and it's existed for decades, is to protect American workers, to ensure that bringing in a foreign worker in this field will not adversely impact the working conditions and wages of similarly situated American workers. That's a really high bar. And to say, hey, we're going to just ignore the interests of American workers, you've got to give justification as to why. And so one of the things that I always focus on initially is, are you working for a US employer? And if you are, why aren't you going the labor certification route? If you don't have a really good reason for that, I'm not doing your case, because that's where we're going to get denied. I'm going to do everything right. And then they're going to say, but this guy should be doing a labor cert.
And the stats show that, like for the EB2 for like perm STEM jobs, it's like I think 98% approval rate, but then it drops down to I think 92% for STEM jobs. And you see something similar with non-STEM, where the approval rate is generally higher with those. And who knows if it's political? Like I can't imagine like there are going to be so many denials at an Amazon or Google.
So I think the idea is, you've got to explain why the labor certification process doesn't make sense for you, right? It might be time. Hey, we need this person working right away, and to complete the labor certification process so we can file an I-140 takes 18 months. And that's just too long, because this is a critical person for our organization, right? That might be a good justification. It could be that the company as a policy doesn't do labor certifications, right? So you're an employee of a company, but they have a policy that says we don't do labor certs for our employees. That can sometimes be an argument. But for the most part, you want to show that it's not feasible, right? So this is where I make the argument that the person is an owner, right? Or incorporator or corporate officer. If the company is so small that we know that the recruitment process is not going to be able to pass muster under the balancing tests that Department of Labor uses. Also, if the person is related by, familial relationship with the owners of the company they work in, they're not going to be able to do a labor certification, because there's challenges in the recruitment process under Department of Labor rules. So these are all reasons why an employed individual can argue that the labor certification should be waived. But don't just assume that I'm a master's, and even though I have an employer, I can do EB2. You have to prove why the labor certification isn't the right way for you.
So we talked a little bit about those employed individuals, but changing a bit to entrepreneurs, consultants, we're a big advocate of forget propose endeavor. It's your endeavor, what you're already doing in the United States. So a lot of our clients have an E2, O1, other visa category. They're already doing some work, whether it's at their own company, another company, and the EB2 it's not propose. It's what they're already doing. Do you see like a difference in adjudication trends in terms of like people working on actual?
So even when I have a client that's outside the US and they're consular, I tell them, look, proposed in theoretical is not great, right? Yeah. I can propose to you that I'm going to get your visa approved. You need something to back that up.
Yes.
So the key here is to take significant steps. If you cannot actually do the work because you're outside, you don't have a work authorization that allows you to actually do the endeavor at the time you're applying, take significant steps towards achieving it, right? Register your corporation. Foreign nationals can register a corporation. Get contracts. Establish a solid business plan. Commit funds to this new endeavor. So you have to you pretty much have to be doing this or be ready to like start doing it as soon as you land. But if what you're saying is, I can contribute my knowledge base and experience to the United States economy, that's not going to meet the standard. And I agree with you. The strongest cases are those where the person is already doing it. It's not proposed. It is happening.
And there's been job creation, there's been taxes paid, especially these E2 visa clients of Visa franchise. They've hired a lot of Americans. There's American contractors, vendors. Some of them have a $1 million plus business where they're spending $700K with employees, vendors, and if they don't get this green card, they could shut down the operation. So I'd imagine USCIS might consider that, as well as the taxes paid and future taxes paid.
So that's what goes back to what we go improving the substantial merit and national importance, right? So it's a substantial merit of the individual's actual endeavor in the United States that we have to prove. So that's what we're going to talk about, the direct impact of the work that they're going to do in the United States. So if they have a business that they're operating, we're going to talk about their critical role within this organization. And through that, the derivative benefits that the United States receives through their efforts, whether it's taxes they pay, employment they create, or the products they or services they produce, and how that benefits more widely, right? One of the limitations that used to be much stronger before DANASAR is the geographic impact of that work, right? So one of the things we have to prove is that the benefit is not just to the company or the local economy in which that organization operates and that individual works. So we're always asking, who are your clients? Where are they located? Who are their clients and services? And try to give as broad an to paint a picture of kind of the domino effect of impact. And you see this in like the EB-5 economist reports, right? When they do indirect job creation, the concept is if you put a development in this area, its impact expands beyond just the physical footprint and the ledger of that investment, right? It goes to the surrounding businesses, the foot traffic it creates.
So that's what we've started doing for the business plans, RIMS analysis, basically an analysis of all the jobs created, whether it's indirect or direct jobs.
Correct. And that's the key, right? Showing impact and showing impact beyond just the individual's business or their direct clients. So it's kind of looking at this macro and being able to paint that picture, illustrate it for the officer. Because I think that's the biggest hurdle of EB2 is how discretionary it is and how the person who holds all the discretion is one officer. And that officer may be in Nebraska, maybe in Texas. You don't know what their life is. You don't know what their life experience is. They may be, they have a couple of hours, maybe an hour to review your case and make a decision. And who knows what exposure they've had to your industry, to your, whatever it is your endeavor is. How are you going to convince this person to take a risk to approve your case? So I think that the easier you can make it, the more relatable and the broader the impact you can show is how you prove the substantial merit. Then the national importance, this is more objective, right? So what you want to prove is that, and this is my opinion, right? Because these aren't clearly defined terms. These are terms that have been interpreted. So in practice, the way we show national importance is to try to look for government, federal, national statistics, reports, executive orders, initiatives that show that the federal government or that the consensus in the nation or some objective body that we can recognize as being a adjudicator of what is important to the nation has recognized the work in this field as important, right? So STEM is great because we've got in the policy manual, due to this administration's leadership, we have language that specifically calls out the national importance of STEM jobs. And we have a ton of initiatives throughout multiple administrations for STEM. We have tons of data that shows that there is a shortage of STEM workers and how this is an initiative that the federal government really wants to recruit more STEM workers because we're falling behind on technology and in different areas, and it's having an economic impact. So these initiatives are why I think we have such a high approval rate of STEM endeavors. Other fields may not have as robust a documentable initiative on the federal level, right? On the government interest level. But this is where a good lawyer comes in. It's all about research. So for example, when I have a client that works in the agricultural business, or maybe they are in the, supply chain of food or raw materials, I'm going to the Department of Agriculture. I'm looking for reports, and I'm looking for initiatives. I'm looking at chambers of commerce or organizations that are national that talk about either the need for people with this knowledge and experience, for resources in these areas. You've got to figure out what's the government agency or the national organization relevant to my client's field of endeavor, and then who can I get to document this for me if it doesn't exist. Sometimes you'll want to get an expert letter, right? A professor from a university that can talk about and write what are the various studies and give you a conclusive opinion that this person's particular work is relevant to the studies that are out there, because sometimes not clearly laid out.
Michelle, how closely does the background of the petitioner need to be to the proposed endeavor? Like an example, a lot of engineers studied mechanical engineering, chemical engineering. Now they work in tech and they're data scientists or software engineers. How closely involved is it? I guess, yeah, I'd love to hear your thoughts.
So my thinking is you just have to have the STEM degree to qualify under STEM. But your endeavor has to be reasonably related to the education you received. Now, you might have an engineering degree and you're working in tech. I've got to pull how the coursework you did is related to the work you're doing now.
Okay.
And a lot of the times you can meet that, right? It's a similar analysis we do in H-1Bs. When you have to show a specialty occupation, you have to prove that the person's direct education is relevant to the role that they're going to be performing. And that there's specialized knowledge that they gained from that education that is required to exercise the role that they're going to do. So I use the same analysis. That's not to say that people don't get their cases approved where their background in education has nothing to do with their proposed endeavor. I just think you're opening yourself up to a denial if you don't link the two.
Well said. Michelle, maybe we could go through some of the questions that are coming in.
Sure.
We have from Armin, thanks. My question is about having a professional plan. What should it include? How is this different from a business plan? So I guess business plan, entrepreneurs, consulting, professional plan, someone working at a company.
Well, I think, the professional plan is more going to be in your personal statement, right? So your personal statement, which is part of the EB-2, is always going to lay out who you are and what you plan to do. And I think this is where you're telling the story and you're speaking directly to the officer to explain to them in terms that they're going to understand what it is you actually do, how you do it, and how it benefits the United States at large. And that's going to vary like so much, right? So if I was to do a national interest waiver as an immigration lawyer, right, my personal statement would talk about my background in education as a lawyer, my personal background as an immigrant and my ability to empathize with my clients, my client base, how I service them, why the way I service them and who I service is something that is unique or niche to me. And then I would talk about what's the greater benefit of the work I do, right? Immigrants create jobs. The kinds of immigrants I help are investing in our nation. The kinds of immigrants I help are being recognized as being of national importance. And so I'm bringing a workforce to the United States that is necessary. So again, your personal statement is going to be very particular to your background. And your job in that statement is to include the criteria, your abilities, citations to something that the officer can look at to say that to understand that what you're saying isn't BS, right? So examples of your work, examples of your achievement, and then a very clearly laid out plan of how you plan to actually implement your skill set and knowledge in the work you're going to pursue in the United States. And that's again where we go back to what Patrick said, the difference between a proposed endeavor, what you're actually doing, or what you've taken steps to assure the officer, I'm actually going to do this. I'm not just telling you I'm going to show up and do this. Here's the steps I've taken so that when I come in, I can hit the ground running.
And then a quick thing for Antonio, tenemos un otro canal, franquicia americana, y Michelle puede puede participar en ese canal en español.
Si ustedes quieren, con gusto podemos hacer un video en español también.
Buenísimo. And then
Patrick, we can do a Spanish video con tu excelente
we have one
español.
coming up in Portuguese, so that'd be good to round up. And then from Alessandro Diamond, common question I've been getting almost daily that I meant to ask Michelle. Any impact expected for applicants after the election? I guess depending who the president is.
Honestly, I have no idea, right? I mean, politics in immigration in politics right now is so toxic. We have the Democratic Party, for political reasons, pushing to shut down the border, right? And take very restrictive immigration policies. I think the initiatives remain for anybody who's economically minded to incentivize investors, entrepreneurs, talented, educated individuals to come to the United States. That makes economic sense to me. But we also have a very isolationist and nationalist sector of our political spectrum that has great influence. And we could see, to our detriment, a political party take over that wants to restrict immigration across the board, regardless of its purpose. I hope that doesn't happen. But again, we have to acknowledge that those voices exist, and right now they're very loud.
And I saw even during Trump's era, Buy American, Hire American, it just working with the business plan, the investment, and the strategy with Michelle is just, okay, how are you hiring American jobs? How are you buying American jobs for that petition? And I think EB2 and a lot of these categories kind of go.
Under the last administration, under Stephen Miller, immigration got brought to a grinding halt. And then COVID extended that. We're still recovering. The Biden administration has done a lot to open up the avenues to immigration, to accelerate backlog processing. But I can tell you that the policies implemented by Stephen Miller were to bring legal immigration to a grinding halt. Requiring interviews across the board for every type of application was impossible. We don't have the resources to do that. Adding all these additional adjudicative requirements to processing applications that slow down how they get processed brought it to a grinding halt. The decimation of Department of State under Tillerson, we lost so many consular officers that are now not going back, and those posts are really understaffed, and the people that are there don't have the expertise and experience on complex cases. So it's easier for them to just deny cases at the consulate than take a risk and approve someone when they don't feel comfortable that they're making the right decision. So it's going to take a long time for us to recover from the damage that was done purposely to stop legal immigration. I think a change in politics, we would see us go backwards again. I think there's always a benefit to being already in line and in process. So I know there's a big push for a lot of people to get their cases filed now before there's a potential administration change in January of next year. But again, I can't tell you with any certainty that a change in political party is going to change these processes. I would hope that Congress would rally around not allowing for significant changes to, go backwards on employment-based immigration. But I think that policy-wise, a lot can be done to slow down a process without congressional legislation. So I think that's where the risk really is inefficiency and people just throwing wrenches into the machine to make it harder, more complicated, and less consistent adjudications. I think that's the real risk we're facing, is more inefficiency should an anti-immigration party win the election.
Michelle, what's the best way for someone to reach out to you to see if they're eligible for the EB2 NIW, or what visa category might be best for them and their family?
So you can go to our website, www.canerofadul.com. And on our website, you can fill out a form to request a consultation. And right there and there, you can select, once you fill out the form, you can select the time that's convenient for you to meet with me or my partners, Maria Eduarda, who speaks Portuguese, and Mirta Fadul. We're all bilingual. We all speak English and Spanish, but Maria Eduarda speaks Portuguese. And any one of us can do the consult. And you can also email me at michelle@canerofadul.com, and I'll be happy to answer your questions. Sometimes you could just send us a resume to my email, and I can kind of look at it for you and tell you, hey, I think this is worth a conversation, or let's talk about some different alternatives. I always think a consultation is a good starting off point rather than an email, because sometimes the resume doesn't tell me the whole story. You might be thinking about yourself, but when we talk, I ask you about your spouse, and we realize that your spouse has a profile that might be better suited either to the EB2 or another visa entirely. So I always think the conversation is the best way to go about it, because then I can look at your whole family holistically, and I can identify any impediments, because that's another thing I see a lot in our practice, is a lawyer will do an application for someone without considering the whole family. And then when it comes time to get the adjudication, we realize that one of the family members is inadmissible, or that the strategy wasn't going to work for them. And then you spend all this time and money, and it's going to go nowhere, because as a family unit, you can't move to the United States in conditions that would be favorable to you.
Well said, Michelle. Well, I want to thank you again for joining, and thank you for sharing all this knowledge.
Oh, happy to, anytime.
Appreciate it. And if anyone is interested in our service, sorry?
I said, thank you for giving us a platform to put this information out there.
Definitely. And then if anyone's interested in our services, whether you want to start a business, buy a franchise, buy a business operational support with the business plan, professional plan, we're here for you at visafranchise.com.
And I will say this, a lot of our clients who call us, they want to come to the United States. They're not sure what kind of business they're looking to invest in or to start. Maybe they have their own businesses. We often direct them to Patrick and Visa Franchise, who also have Spanish speakers, to help guide them on feasibility and provide them options. One of the biggest problems for foreigners that are coming to start a business in the United States is that it's difficult to navigate how to start a business, what kind of businesses will operate, understanding the financials. Patrick and his team have a lot of options, and especially in the franchise area, are very well studied. And that can give you a framework to begin your investment safely, right? Because you have a framework, you have an infrastructure, you have some predictable numbers, and that's a good place to start your investment and then grow.
Really appreciate that, Michelle. And yeah, our team's very direct. We tell it how it is, and we back it up with data. Thanks so much for everyone. Until next time.
Thank you.